WOCA.
All right, 25 minutes before 11 o'clock. Thank you for tuning in. It is time for Legally Yours. John Fuller is here. He's the host of this program. John is an attorney at the law firm of Fuller & Fuller here in Ocala. The other Fuller is his beautiful wife, Janet, who we've only seen, I think, twice since John's been doing the show. And, of course, your questions are a big part of this show, so we invite you to call and speak to John. And it doesn't have to be a question. It could be a statement of some sort. The phone number is 622-9622. That is the WOCA Climate Control Source Hotline. Good morning, John. How you doing?
Good morning, Larry. Yes, Janet, Wednesday is usually her day in our village office.
Is that right?
She has a number of appointments each Wednesday that she sets for people who have Social Security disability claims and issues. So it's hard to get her here. I wish, I keep telling her we need to swap off, but she's the Social Security expert, and so she handles that in the villages on Wednesday. But it's good to be here, and look forward to perhaps dealing with some of our listeners' questions about potential legal issues, the legal system. As you know, our law firm, Fuller & Fuller, handles civil litigation involving accident cases, commercial business litigation, and Social Security disability, and some complex family law issues that have usually a business component to it. So those are the areas that we focus our practice in, but if we can help anyone in general terms, that's what the purpose of this program's about.
Excellent. And we've kind of had a legal kind of a day. We had a mediator on earlier this morning. You just probably crossed paths with the professor of criminal justice from St. Leo. He was in here with the last show.
Is that right?
Yeah.
I did not know that. I would have liked to have met him. Many years ago, I was an adjunct professor teaching a course in the criminal justice master's program at Rollins College.
Oh, wow.
And it was a really pleasant, challenging experience. I had never taught before, and certainly never taught a graduate level college course, and I have unlimited respect for teachers at every level because it is very hard work.
Regardless of the age of the student, right?
Absolutely. I worked very, very hard preparing for and teaching that course, but it was very rewarding, and I was glad that I did it. It was a night course, a 3-hour lecture course once a week with Rollins, and fascinating experience. I don't know that I'd want to make a steady diet of it, though, because it was extremely time-consuming and challenging.
So can I ask sort of a personal / professional question?
Yeah, sure.
When you were studying law, I mean, now you have your own law firm. Did you work for another law firm before you opened your own?
Oh my gosh, yeah. When I was in law school, at that time, law school did not have elaborate intern programs or training programs for practical experience, and I felt that was a very, very important thing to have. So I was in Gainesville. I came home for the summer, and I went to law firms throughout Ocala and asked if I could work as a law clerk. I told him I wasn't even interested in a salary per se. I wanted the experience.
Oh, really?
I wanted to be a part of the working up cases and that sort of thing.
Right.
I'd finished 1 year in law school, and at that point it was ironic because only one law firm in Ocala had ever had experience with law clerks, and that was because one of the partners had been a law clerk in a large firm in Fort Lauderdale when he was in law school. And that was Savage, Crim and Simons. And I went to work there in 1971 as a law clerk in the summer. I continued on there, ultimately became an associate, then became a partner and practiced law there some 18 or 19 years. and had a wonderful time. They're wonderful people. Wanted to start my own firm, and another gentleman and I started a two-man firm in the early 1990s. He's a Harvard graduate who had been a partner in a 120-man law firm in Miami.
Wow.
He had moved to Ocala because of his family being in the Arabian horse business, and he and I opened a small two-man boutique commercial litigation firm in the historic district, and practiced there together for 3 or 4 years, and we started growing. We had more work than we could do. We had outgrown the physical office facility. We had added 2 other lawyers, and we then merged with another law firm and ultimately had an office in Miami and one in Ocala.
Wow.
And I practiced there, and that was with Steve Gray and Bryce Ackerman and Tim Haynes, who were dear friends of mine. And then in about 1998, I became a partner at the Ayers Cluster Law Firm and was a partner there for a number of years until Janet and I decided that at this stage we wanted to be captains of our own ship, to have a little more hands-on control of the nature of the practice and what we did and how we did it. So we opened our own law firm in 2011, and it's been we've been very blessed. We have very good clients who we're just very grateful for the success that our law firm has had, and we hope to continue providing good legal services to people who may care to call and consult with us.
Do the people that we might speak to at the courthouse have a legal education, or not necessarily?
Well, it's a broad brush. They have people there who have no legal education.
Or maybe the better question, can they answer questions?
They have, security guards. They have custodial people. Those folks, obviously, I don't think that's obviously what you were talking about. The people in the clerk's office all have training in the area of expertise that they're working in. If you go in to do a do-it-yourself divorce case, which you can do, they have extensive forms, instructions, and the people at the clerk's office do a very fine job in assisting people who want to try to handle cases for themselves. The same way with the people in the small summary claims department. They have good training. David Ellsperman does a great job running the clerk's office. He is an outstanding circuit court clerk, or court clerk. He hires good people, and he trains them well. He supervises them well, and my office is dealing with the personnel that work with David at the clerk's office has always been pleasant. They're efficient, they're effective, and they're always very pleasant to deal with.
And looks like you have a phone call coming in. Let's take that call. Oh, we just bailed out for some reason.
Sorry.
No, it was instant. Maybe they realized I had a wrong number. But I would like to invite the listeners to call. The number is 622-9622. The area code is 352 if you're out of the area. 352-622-9622 to speak to John Fuller. And now you do have a few calls coming in. Good morning. You're on the air with John.
So I've got a question about a deed to property. It's paid for, and on the deed itself, it says 14th Avenue. It's actually 13th Place. The plot number or plat number, that's all right. It's just the actual address wrong. Where do we start getting that fixed at?
Now, I'm going to need some help with the question because I could not understand.
I wasn't sure either. Could you repeat it again, please?
Yes, we've got a property in Alamo paid for and everything, but on the deed to the property, it's got the lot and plot number. It says 14th Avenue. It's actually 13th Place.
Okay, her deed has the wrong address on it.
Well, the address on the deed, if it's just in the preamble to it, that ideally that should be fixed. But the critical part of the deed is the legal description, whether it says a lot and block number or whether it is a more involved description that has what we call meets and calls, where you have distances and angles to define the size and description of the property. It would seem to me that if you have a deed that has a facial error on it, you should talk to a real estate lawyer, and it could be corrected simply if you still can contact the person who signed the deed conveying the property to you. That's known as the grantor. And if you can locate that person, you can do a corrective quitclaim deed, they call it, get them to sign it and record it, and that will take care of any inconsistency or error that is in the deed. If they are no longer available, then you have other remedies. They're a little more involved. You would file a lawsuit to reform the deed, saying that the deed contained a scrivener's error and needs to be corrected to correct the location and description of the property. So I would, number one, I think it would help you very well to go get a real estate lawyer and let him take a look at the deed. If he thinks that the defect in it is critical, he can do a corrective deed and contact the person who you originally got the property from and see if they will sign it before two witnesses and a notary public, return it to you, and he will then record it in the public records of Marion County, assuming the property's in Marion County.
Yes, sir. The builder still lives in our subdivision that actually built the house. Did it take down to him?
Who? I'm sorry?
The builder.
The builder, the man that built the house.
Is he the one that sold it to you?
Yes.
Okay, well then, you know, that's who you need to go back to get the deed corrected. And if he's still in business, you know, I mean, I think I think it's always wise when you're involved in a legal transaction to consult with a lawyer. Many people don't. Many people handle things just fine. I'm sure he's a very fine builder, but you have evidence that he's not the most sophisticated deed drafter. So maybe you might want to seek some professional guidance before trying to get him to fix it, although it doesn't sound like it is a major problem, but I think it needs to be addressed. And it's a lot easier to address it now while everybody's alive and in business in Ocala, rather than to wait until people move, people die, you know, what have you.
Right, right.
So good luck to you.
Thank you.
Thanks for calling.
Thank you for the call. All right, phone lines are open again. It looks like you have another call coming in. The number, if you would like to call, John, is 622-9622. Good morning. You're on there with John Fuller.
Yes, good morning, Mr. Fuller.
Good morning, sir. How you doing today?
Very good, thank you. Several years ago, we had kind of a very tragic accident in our family, which happened up north. My nephew, at work, was involved in an accident and lost his limb from his knee down.
Wow, I'm so sorry.
Yeah, several years have passed now, and it's been going back and forth with lawyers with the company and this, that, and whatnot. And finally, the company has admitted total negligence and at being at fault. And I believe they're going to be going in what they call arbitration.
Probably mediation, but that's
mediation. Yeah. How does that work now? Is there like a schedule, like a menu for how much a person can sue for loss of a limb, like a leg or a finger or a hand or an arm? Is there a set amount on the limit?
Well, if the injury and loss occurred in a civil case, and if it was in Florida, you mentioned it was out of state, so all bets are off because I don't profess to know any of the laws of other states. But if it is a civil case where you're in a car wreck or you fell on a defective sidewalk or some premises liability thing, there is not a scheduled damage where the loss of a limb is worth X, the loss of an eye is worth Y, you know, that sort of thing. It depends upon what the provable damages that were causally related to the injury are. And that varies from person to person. A great example of that is if you were tragically in an accident and lost 2 fingers on your left hand, but you work at a desk practicing law or being an accountant or being a businessman, you're probably going to be able to continue with the same degree of efficiency at your workstation and produce the same amount of income in the future. Now, if you are a concert violinist and you lose 2 fingers on your left hand, you have lost your career. So those are the things that determine what are the amount of damages that a person has in a civil case. Now, I am not a workers' compensation lawyer, so I will not go into this in any detail because that's out of my area, but they do have, as I understand it, certain scheduled injuries in workers' compensation, so that if as a result of an on-the-job injury you lose a hand or you lose an arm or you lose an eye or you lose a leg, they are certain scheduled damages that there's a certain amount of definite damage related to that particular injury. You also get medical bills and lost wages and stuff like that too. But that's a schedule that I am aware of, but not involved with in my practice because I do not do work comp.
Okay. Well, thank you very much for your answer.
Always a pleasure. Thank you for calling.
And again, the phone lines are open if you'd like to speak to John Fuller. 622-9622 is the WOCA Climate Control Source hotline to speak to John. Marco Rubio's in the news. He was jury duty this morning. He had to do what I did.
Who's that?
Marco Rubio, the senator. Marco Rubio.
I did not know that.
Yeah, he had to fly down from Washington to go to Miami to go to the courthouse down there and probably sat all morning like I did.
Well, I always, I've told you before, when you went through that a few weeks ago, I have great respect. That's one of the 2 fundamental duties of citizenship: vote and serve on a jury if called.
So I wonder, when they realize it's a senator, will that affect their decision, or maybe not? Huh?
Well, I don't know. It depends on the nature of the case and what their concerns are about finding someone who has an open mind without any preconceived knowledge or biases, prejudices about the issue. So, it depends on the case. I will tell you that as a trial lawyer, I would be rather skeptical of having someone who was in a high-profile position like that. I would be fearful that he would dominate the deliberation process, and that the decision would be his and everybody else would go along with it, rather than a collective effort of the combined talents, intelligence, reason, and common sense of the whole jury, which is the way it's supposed to be. So I would be concerned about that. And then I would also be concerned about preconceived ideas, preconceived opinions. Obviously, being in politics, he's taken positions, he's articulated them, he's argued for them. I'm not saying him individually, just people in that area. So, I think you would look at it carefully. Have another call?
Yes, sir. Good morning. You're on the air with John.
This is very interesting about Senator Rubio, and I have a question for Mr. Fuller. I guess you call it voir dire. How do you say that, sir?
Voir dire?
Preliminary questions for the juror?
Right. It's 2 words, V-O-I-R-D-I-R-E, voir dire. Some people call it voir dire.
Are those questions and answers, are they a matter of public record?
Yes, it takes place in the public, in the courtroom. Anybody can walk in and see it. The questions and answers between the lawyers for the various parties and the prospective jurors are recorded by the court reporter. So it's all a part of public record, yes.
So in other words, if a senator, I'm not speaking specifically of Senator Rubio, but if a senator was to go before a jury, selection process, and the prosecutor asked the senator, "Do you believe in capital punishment?" or something, rather controversial, and that the senator's answer would then be a matter of public record. Am I understanding correctly?
Yeah, the question, I mean, you know, if you're there trying a dog bite case, you're not going to be allowed to ask him, do you believe in capital punishment, or something that would have a separate agenda from a political arena. But if you're dealing with a capital murder case, that is a reasonable and fair question that is asked by both lawyers on both sides of the case in every capital case that has ever been tried. They are people, very good, conscientious people, who are fundamentally and philosophically opposed to capital punishment. No matter what the crime, no matter what the facts or circumstances that involve it, they simply cannot go there, and therefore that individual, capital punishment is part of the law of the land of the state of Florida. And if you're going to serve on a jury where that is an element, you have to be able to say, I have an open mind about that, and I would listen to the law as instructed by the judge, and I would weigh the evidence as presented during the case by the prosecutor and the defense lawyer. I would keep an open mind, and I would do my very best under my sworn oath as a juror to apply the facts to the law. And if I determined that the facts warranted a conviction and capital punishment, then I would not have a philosophical opposition to it, that it would make it impossible for me to make that decision.
Jury selection is a fascinating topic. Thank you, sir.
Yes, sir. Thanks for calling. Jury selection is a fascinating topic. Many people say it's probably one of, if not the most critical, probably the most critical aspect of any jury trial. However, I also want to make certain that I go on record, because you call it jury selection, but the lawyers don't have the right to select the jury. It's a rather random process. People are called because they have a Florida driver's license, and then they're in the jury box, and you get to ask them questions, but you don't get to have an unlimited number of challenges to excuse those people from jury services. In most civil cases, you have 3 peremptory, meaning challenges without cause, and when you use those 3 challenges, absent some technical exceptions, you're done, and that's your jury, like it or not.
Yeah.
So it's a very it's a very difficult process. It's a process that is sometimes more art than science. But you know, the pole star of selecting a jury is to find people who have an open mind, will listen to all the evidence, will pay attention, and will not start making up their mind until they've heard all the evidence and they get back in the jury room. And the theory of a jury trial is that the collective judgment of 6 citizens sitting in judgment of another citizen provides a better comprehensive decision-making process, because the collective effort of an enlightened 6-man jury made up of citizens is a great focus and great feature of our justice system.
And I thought about something you said a few weeks ago, just yesterday, I guess it was, when there was a news item about the young man who was acquitted of killing his little cousin.
I saw that in the paper. That was a 4-week criminal trial.
Yeah, and I thought, okay, I'm a person reading the news. I thought he was guilty, but the jury obviously had more information than I had, and acquitted him.
Well, you know, and I appreciate you making that distinction and acknowledgement of that, because it's real easy when everybody's sitting back and only making opinions on little snippets of news articles and that sort of thing. That case, and I know nothing about it, but it had a large amount of very sophisticated expert testimony.
Wow.
And that shows how important that is.
Yeah, and again, I appreciate you pointing out that we, the public, have a minuscule amount of information, and it often can be slanted because it comes from reporters.
Right, and I think that goes doubly true for people involved in the media who report on trials, because they don't sit there 8 hours a
right.
day. They can't afford to. I understand that. But it's often easy to get it wrong when you only stick your head in the courtroom and sit there 30, 45 minutes out of an 8-hour day, and then you have to make your deadline.
Exactly. And we do have another phone call. Good morning. You're on the air with John Fuller.
Hi, good morning. I got an easy question for you.
Very good. How are you, sir?
Good, thank you. Did they stop calling people for jury duty at a certain age?
You know, that's a very good question.
I don't get called anymore. I'm 72.
Yeah, that's a very good question, and I have not read the statute lately on that. I'm going to hazard an educated guess. I don't think they arbitrarily disqualify potentially calling people because of their age. However, when a person reaches a certain age, and I can't remember exactly what that age is, whether it's 65 or older, but you can automatically have yourself disqualified if you are over a certain age. And again, these are little nuances that you don't deal with every day, and so I can't be more specific than that.
Well, I know Marco Rubio is not at that age yet, so he's not off the hook. Well, John, always fun, always educational. How do we get a hold of you?
Our office number in Ocala is 352-547-4292, the law firm of Fuller and Fuller. We have a toll-free number for convenience of out-of-town clients, 855-534-2565. We have offices in Ocala and in the Villages. If we can help you, or if you have friends or family who have been injured or have questions, please don't hesitate to call us. We'll do our best to help you.
All right, pretty quick half hour it is.
Went fast. Nice questions. Thanks to all our listeners for taking the time to call in. It's your show. It's a team effort, and I really appreciate your taking the time to call.
Absolutely. Show is called Legally Yours, by the way. John Fuller from the law firm of Fuller and Fuller. Thank you, John.
Thank you, Larry.
All right, we'll be right back.
Ocala's information station, 1370 WOCA. Ocala.
ABC News Now. I'm Karen Chase. New York City police wearing face masks are responding to an apparent apartment building explosion and collapse that sent bricks and other debris flying and heavy smoke billowing for blocks. At least 11 people have been hurt, most not